Welcome to the deep dive. Ever feel like something just wasn't right, like legally? Today, we're diving into situations where someone's carelessness causes serious harm to your emotional well-being, like a legal injury. It's negligent infliction of emotional distress, or NID for short. And to help us make sense of it all, we have expert speaker here.
It's more common than you think. We're not just talking about feeling upset. This is serious stuff. Imagine someone's negligence leading to a near-death experience. The law recognizes the trauma from that can be just as damaging as any physical injury.
Okay, so more than just a bad day. What makes NIED a legal case then?
Good question. Think of it like a recipe. You need all the right ingredients, what lawyers call a prima facie case. 5 essential elements, and you need them all.
The basic things you need to prove to even have a case. Okay, I'm following. What's the first ingredient in this recipe?
First up is the injury itself. In NID, it's pure emotional distress, meaning the harm is emotional, not a broken bone, but genuine psychological suffering.
A real emotional wound. Got it. What's next?
Second is duty. The person you're claiming caused the distress, legally the defendant, they got to have a legal duty to act in a way that would prevent that emotional harm. Like a therapist has a duty to their patients to provide a certain standard of care.
Makes sense. It's like a responsibility because of their role or relationship. We don't owe that duty to just anyone, though, right?
Exactly. That brings us to ingredient number 3, breach, meaning the defendant didn't live up to their duty, acted carelessly, recklessly, fell short of what's considered reasonable. Imagine that therapist, totally ignoring clear signs of suicidal intent. That could be a breach.
So they had a duty, then failed. Got it.
What are the last 2 ingredients to round out this NIE breach recipe then? The final 2, these are all about connecting the dots. We need actual causation and proximate causation. Actual causation is like a direct line. You have to show the defendant's breach was the reason for your distress. No breach, no distress.
So yeah, prove their actions caused the emotional harm, direct.
Exactly. And then there's proximate causation. It's asking if that emotional distress was it a foreseeable consequence, like, ripples in a pond. The law cares about the ripples from the initial splash, not some unrelated wave.
Okay, so cause and effect. So if I understand, it's not enough to just be upset. There has to be that direct link from their actions to your distress, and it has to be the kind of distress a reasonable person could predict, right?
You're getting it. And here's where it gets interesting. The law recognizes we don't owe everyone the same duty of care when it comes to emotions. You can't be on the hook for every random stranger's feelings.
That makes sense. You can't be liable for every random stranger's feelings. So when his duties kick in.
There are some important exceptions. First up, what the law calls special relationships. These are where the law says, hold on here, there's a higher level of responsibility for someone's emotional well-being.
Like a doctor and their patient.
Exactly. Relationships with a power dynamic or where one relies on the other for safety, guidance, emotional support. These come with a greater duty to consider emotional harm.
That makes sense. You're more vulnerable, so more protection. What's another exception then?
This one's when someone's carelessness puts you at immediate risk of physical harm, often called the zone of danger rule.
Oh, wow. So like if someone's texting and driving almost hits me, even if I'm fine.
You're in the zone of danger, right?
Yeah.
Physically unharmed, maybe, but the emotional distress from that near miss, grounds for an NED claim, even in near miss, can leave you shaken.
Wow, I hadn't considered that. But yeah, terrifying.
Oh.
Are there any other exceptions to this rule?
One more. This one deals with the emotional trauma of seeing a close relative get hurt. Imagine witnessing a loved one get hit by a car because of someone else's negligence.
Oh gosh, that'd be awful.
Right. And the law gets it. That emotional distress, it's a direct and foreseeable consequence. So even if you weren't in danger yourself, witnessing that harm to family, an IED claim.
This is heavy stuff. 5 elements, these exceptions. It's giving me a lot to think about.
It's fascinating, isn't it? How the law tries to draw those lines between everyday stress and severe emotional distress caused by someone else, and how it's evolved, too.
So we've talked about those closer connections where emotional harm is more, foreseeable. But what about situations where anyone, regardless of their relationship to the person at fault, could be affected? Like that zone of danger idea. Are there any well-known cases that show how that works in real life?
Absolutely. One that really highlights this zone of danger is Robb v. Pennsylvania Railroad Co. Imagine this. A woman is driving over railroad tracks, her car gets stuck, and she barely escapes before a train, barrels through.
Oh my gosh, that's terrifying. I can only imagine how emotionally traumatizing that would be.
Totally. It's a crazy scenario, and the court agreed. Her fear was totally reasonable and a direct result of, the company's negligence. Even though she wasn't physically hurt, the court said her emotional distress from almost being hit. Totally grounds for an NIED claim.
So that case feels like a turning point, like the courts were starting to see emotional distress differently. They were understanding that even without like a broken bone, the emotional impact could be just as real.
You got it. Which brings us to a super important concept in NID law, the restatement, third, of torts, specifically Section 47.
Okay, let's break that down a bit. What is this restatement and what's so important about Section 47?
Think of the restatement as like a guide to understanding the law. Judges use it all the time when they're making decisions. And Section 47, it's all about liability for causing emotional distress.
So not a law itself, more like a legal playbook.
Yeah, exactly. Section 47 lays out two main situations where someone can be held liable for causing emotional harm through their negligence.
Okay, I'm all ears. What are they?
Well, the first one lines up with that zone of danger rule.
Yeah.
If your negligent actions put someone in immediate danger and their emotional distress is a direct result, you could be held liable.
So even if they weren't actually, touched, the fact they were this close to being harmed because of your carelessness, that's enough.
Exactly. The emotional impact of a near miss is real. And the second situation under Section 47 covers when the negligence happened during certain activities or in certain relationships where emotional harm is, well, more likely.
Like that study, a broad organization having a higher duty of care for students with host families because of that element of vulnerability.
Yes, the restatement knows that in those specific situations, emotional harm is, pretty much a given. Negligence there.
Yeah.
Way more responsibility.
Okay, this is all making sense, but I have a feeling it's even more nuanced than this, right? Like, how does a court decide what falls under zone of danger?
Always nuances. You're right. Let's look at a case that really shows how important the zone of danger criteria is. Consolidated Rail Corps v. Gottschall. Actually, this one had two different claims, both about emotional distress at work.
Two claims, one case. Okay, tell me more.
So in the first one, you have a man who's working on a railroad, and he sees his friend, his coworker, have a fatal heart attack right there. The conditions were awful, by the way. Crazy heat, super grueling pace, and the court ultimately decided that this guy, he was in the zone of danger himself.
Because he had to deal with those same dangerous conditions every day.
Exactly. He wasn't just watching his friend die. He was in a situation where it could have been him, His distress was from a real and immediate threat to him.
That makes zone of danger very clear. What about the second claim in the case? Same outcome.
Here's where it gets interesting. The second claim, this time it was a railroad worker. He wasn't in immediate danger, but he had, severe depression and anxiety from the stressful, really demanding work.
Similar outcome then. I mean, they both had legitimate emotional distress, just from different things.
Not quite. This is where it gets tricky. His distress was real, for sure, but the court said he wasn't in the zone of danger in the same way as the first worker. His emotional harm, it didn't come from being at risk of being physically injured at that moment. It was more from the overall job.
So even though they were both under a ton of stress from working on the railroad, the court saw them as totally different in terms of NIED.
Exactly. And that's why Consolidated Rail Corp v. Gottschall is so important,
Yeah.
It shows how courts draw that line between emotional distress that comes from fearing for your immediate safety versus, more general stress, unhappiness, even if those feelings are totally valid.
Talk about a fine line. Seems like proving NIED would be tough, even with all of this laid out like this.
It's complicated, for sure. But that's why understanding these little things, the nuances, is so important.
So we've covered so much ground here. The 5 elements of a claim, those exceptions, even those real-life examples, it's a lot. For someone who's been listening to all of this, what's the main thing to take away about NIED? What's the one thing you really want them to remember?
That their emotional well-being matters. The law doesn't cover every hurt feeling, or daily stress. But it does recognize that sometimes when someone's negligence really does cause serious emotional harm, you've got legal options. Those invisible injuries, they're real.
That's such a good point. It's not about being too sensitive or anything like that. It's about knowing your rights, advocating for yourself, especially in those situations where legally the harm is legitimate.
Exactly. And, if you're ever thinking a situation might be NIED, think back to those cases and principles we talked about. That's a good starting point.
Right. Knowledge is power. And just knowing the law recognizes how real emotional distress is, that can be powerful in
I
itself.
agree. Makes you think about the bigger picture too, right?
Definitely. Like, how could our understanding of emotional distress, how could that shape the law going forward? What new legal questions might pop up?
That's interesting. Will there be new laws to protect people in situations like, say, online harassment that can be really damaging?
That's a great question. It makes me think about cyberbullying and NIED claims. That's a whole new world of potential harm. How would the law adapt?
Definitely something to keep an eye on. As technology changes, social norms change, you know, we'll probably see a lot more NIE cases pushing those legal boundaries.
It's a lot to consider. Well, this has been a fascinating deep dive, a complex area of the law, to say the least. Thank you for joining us and exploring this important topic.
My pleasure. These are the kinds of legal puzzles I love to unpack.
And to our listeners, we'll see you next time for another deep dive. We'll be taking on a new and interesting topic, so be sure to join us. Until then, keep those brains engaged.